I want to thank the New Mexico SBDC for hosting this, and I want to tell you about, they have a lot of great resources, and they're almost single-mindedly focused, and that's not fair because they have a lot of great resources, but they're really focused on helping businesses dealing with the COVID-19 issues and the pandemic, and there's some resources here. The presentation that I have will be available to you upon request if you contact the SBDC, and so you'll be able to have access to these links so you don't have to write them down or take screenshots unless you want to. Today's overview, we're going to be talking about litigation, and I know that sounds like a very boring topic. I'm going to try and make it exciting a little bit by offering up some examples and testing everybody, but it's really a little bit of an educational exercise about how our courts and the U.S. jurisprudence works. And I think it's important to understand that, and that'll really help you better understand how to manage your business so that you don't have to deal with a lawsuit. We're going to learn a little bit about what a lawsuit is and how to reduce risks to mitigate or minimize the chance of lawsuits, and then what to do if you are sued. The first question is, what is a lawsuit? I know this seems like a dumb question, but bear with me. A lawsuit is where you have one party, typically the plaintiff, but if we are talking about not the civil context, but the criminal context, who's the plaintiff? It's the prosecution, the prosecutor, the state. So the plaintiff is asking the awesome power of the government to resolve a claim or dispute against the other party, typically the defendant. So in order to maintain a lawsuit, you need three things. You need a duty, a failure of that duty, and damages. If you don't have any one of these three, you can't maintain a lawsuit. That doesn't mean somebody can't try to sue you, but you will be able to usually get that lawsuit dismissed pretty quickly. What is important to understand is the court is what's called a trier of fact. What does that mean? Well, you have your facts and you have the other facts, the other side. They have their facts. And the court doesn't know any better. They don't know if your facts are the correct facts or the other guy's facts are the correct facts. And many times with businesses, we have specialized issues. Were the premises sanitary? That might require an expert witness to come on in and present additional facts on what sanitary means. So that's what a court does, is deal with all the facts. And I can't tell you how many clients get very frustrated in the lawsuits, and they're like, can't we just talk to the judge and tell them our side of the story? And the answer is yes, you will get a chance to do that. But judges have many cases, so there's a docket, there's a timeline, and I'll talk a little bit more about some of that. But it's important to understand that once you go to court, we kind of lose the timeline. The court controls the timeline. So we'll explain why that's such a big deal. But before I do, what is a legal duty? And it's important you understand what it is. It is something that can be created by statute. For instance, a duty to collect and pay taxes. A statute can restrict behavior or require you to do something. And then, of course, depending on the type of business you're in, you may need licensing or permitting. All of those are duties that regulate you and your business. It can be created by contracts between two parties. So if you don't have a relationship with someone and there's no contract, there may be no duty for you, but beware, there could be implied duties or presumptive duties. And I have listed here a few of those as examples. You can have a fiduciary duty just because you are safekeeping something. Let's say you're a restaurant and you have valet parking, and so somebody's giving you their car keys. Well, guess what? You have a fiduciary responsibility associated with that vehicle during the time that you take willing possession of that vehicle. There are implied warranties depending on the type of business you're in. Examples would include, title, merchantability, fitness for a particular purpose, non-infringement. You have a duty of care in many instances. Most businesses have a duty to not be negligent or gross negligent in what you do, no matter what it is you do. There are for tenants an implied covenant of quiet enjoyment, which protects you against certain circumstances that the landlord may throw you or put you through. There's also a duty to warn, for example, and that will involve safety risks involving the premises or the certain products. And what do I mean by premises? Well, if you have a wet floor and it's slippery, you better dry that floor quickly. And if people are going to be walking through the moisture, you need to put some warning signs up there. Otherwise, I promise you, you're going to have a slip and fall and you're going to have a lawsuit. So you can also have a legal duty by court order. And we hate those. We don't like court-ordered duties. And that usually means you were sued, you lost, and now you have some sort of duty to pay. You have an injunction to either do something or not do something. So we really want to avoid the court-ordered duties. But let me give you some examples. We're going to go through 4 of these real quick. Here's the first example. You own a business and you don't collect, report, or pay New Mexico gross receipts tax in New Mexico. First question, do you have a duty? Yes, you do. To collect, report, and pay New Mexico gross receipts taxes. This one's a pretty easy example, isn't it? What's your failure of a duty? It's, do you have a failure of a duty? The answer is absolutely. If you're not collecting, reporting, and paying New Mexico gross receipts tax, you have an absolute duty to take care of that. What are the damages? Well, the damages are the state doesn't get its pound of flesh. So I promise you they're going to go right after you for that. If you do not collect gross receipts tax, if you think a client doesn't have to pay it or a customer doesn't have to pay it, so you don't collect it and you're wrong, does that mean you don't have to pay it? No, the state's going to come after you with penalties and interest. And we've had cases where gross receipts tax was under collected over a period of time. And one in particular I'm thinking of, it was somewhere in the range of $60-something thousand. And when everything was said and done, the state was going after our client for over $200-something thousand. So a little bit of uncollected gross receipts tax can turn into a very significant amount of tax owed and due to the state. Here's another example. You own a business and you don't like to hire older folks due to the demands of the job. Do you have a duty here? Sure you do. To not discriminate on the basis of age. In the Title VII is one example, depending on the size of your business, but there are many other federal and state laws regarding age discrimination. You do not want to do it. So did you fail on the duty in my example? Yes, you did if you hire on the basis of age. However, we said you have concerns about the demands of the job. You can certainly hire based on qualifications or fitness for a particular job. For instance, if somebody's going to be lifting heavy stuff from point A to point B, what you can do is hire on the basis of the ability to do that job, but do not do it based on age or handicap or something like that. You can't do that. And what happens? What are the damages? Well, yes, you have damages here. And in this particular case, as well as many others, there are presumptive damages. So just because somebody, you didn't hire somebody and they find another job the very next day, so what are their damages? Nothing. No. The law will presume damages, and they're called statutory damages, and they tend to be quite severe. So we want to avoid statutory damages in every instance. Let's give you another example. You own a business and you misrepresent the scope of your services. And I didn't say intentionally. This could be an unintentional misrepresentation. You say you're the best in New Mexico or the fastest. You use some sort of general qualification. That could be potentially a misrepresentation. Is there a legal duty for you here? Yes. It's called you have a duty not to misrepresent, and I put it in quotes here. And there's many other duties associated with what is called the New Mexico Unfair Practices Act. And one of them is not to misrepresent the characteristics, the ingredients, uses, benefits, or quantities or qualities of your product. What happens if there's a failure of a duty? In this example, yes, if the plaintiff can prove you misrepresented it and they relied on that misrepresentation, what are the damages? Well, the New Mexico Unfair Practices Act is terrible for merchants. And the reason being is it permits recovery up to 3 times actual damages plus attorney's fees. And if you think about that for a moment, let's say you're a web developer and you say, oh yeah, I'm going to give you the fastest website there is. And your website is just a normal website. It's not the fastest there is. What are their damages? Well, their damages, they're going to argue, is everything they paid you plus everything they had to pay a new web developer to get the fastest website around. So that's your fees plus the other fees times 3 plus their lawyer's fees if you want to fight this. So you want to be really, really, really careful with misrepresenting, and you want to document exactly what you are or aren't promising. And we're going to go over some of that here in a few minutes. We're going to do one final example here before I go on and give you some, we talk more about avoiding litigation. You own a business and your website says, we'll repair or replace faulty work. That's all it says. You know, you guys have a great warranty. If it's a problem, you'll fix it. But you don't mention any limitations or exceptions or exclusions. Why would you do that on your website? Well, after the 5th time, you're asked by a customer to replace flooring that you installed that keeps cracking due to a faulty foundation. And finally, by the 5th time, you refuse. Do you have a duty? Yes. Your duty is to repair or replace faulty work. And they're claiming you have faulty work because it keeps cracking. Well, you don't have any limitations or exceptions on your website. So the question becomes, what would a reasonable person believe or say under the circumstances as it relates to repairing or replacing faulty work? Well, I think we're all reasonable people here, I would assume. So what would you say? Well, the answer here is possible. What is the reasonable person standard? And, you know, if you have a contract, and this is in the contract, and you generated the contract, well, ambiguities are interpreted against the drafter. So this doesn't look good for you, but a reasonable person surely would conclude that if it's cracking not through your faulty work or, you know, because of your materials, but because of a faulty foundation, I think a reasonable person would claim you probably don't need to do it, as well as I would assume a reasonable person would say you shouldn't have to do it 100 times either. But we're probably going to have to fight that. We're going to have to hire experts in foundations and, you know, probably have an inexpensive fight on our hands. So we probably wouldn't want to do that. But are there damages here? Yes, of course. The flooring needs to be fixed or replaced again. So somebody can certainly sue you on this basis, even if they might not win. It depends on where the jury would come out at. But what you have to understand is lawsuits are very, very expensive. And I'm going to explain the issues around that in a few minutes. But the question becomes, how do we minimize the risk of lawsuits as a business? And the answer is, you manage expectations, you take precautions, and I want you to be smart. And I'm using SMART as an acronym here. I'm going to explain that in just a minute. But you want to be careful when you're creating legal duties with third parties. And how do you create legal duties with third parties? Well, you interact with them in some way. And therefore, now you have to deal with statutes or legal duties that could be presumed. Remember, I mentioned that. Or you can have legal duties by contract. Interestingly enough, contract allows you to sometimes eliminate or reduce or manage those legal duties that are created by statute or by presumption. So for example, you know, I have a duty not to slap you, right? That's called a battery. But I can get you to sign a contract that allows me to slap you. So when I slap you, you can't sue me for battery anymore because we actually contracted. I know that's a crazy simple example, but I want you to think about that because If you have the right contract, you can minimize and reduce some of the liabilities associated with dealing with third parties and third persons. And I've listed the major categories here, and we're going to talk about them a little bit more. But you have employees and contractors that you hire, and you want to make sure that you have the right contracts in place to establish their status and do other things. And you have the same thing with partners in business, clients and customers, and your vendors, including landlords. The other thing you need to do is document. And when something happens, you need to make it a business record. So what is a something that's important? Well, if there's an incident, for example, there's a run-in with a customer, an employee gets hurt, or there's an accident, you should document all of that stuff as a formal business record and keep track of it. So SMART goals are also important, and you should establish SMART goals with yourself and with everybody. And you can Google this. Google what is a SMART goal, and you're going to see a lot of great material on it. But SMART is an acronym for specific, measurable, attainable, relevant, and time-based. You want to establish goals that are SMART, and you need to be realistic and document your performance so you can show you're meeting your promises and managing people's expectations. You also, it's important to know the law in key areas, especially what it is you're doing. That will help you avoid lawsuits, obviously, because if you violate the law, somebody's going to nail you. And even if the law doesn't give a third party a cause of action, it causes them harm, they're going to sue you for what's called negligence per se. They suffered damages because you didn't follow the law, or you broke the law somehow. And then finally, stack the deck in your favor. And I'm going to explain what I mean by that shortly. Stay in control of the relationship when you're creating a legal duty. So for employees, it's important to know the difference between a 1099 and a W-2 classified employee. And remember, it's not what the contract says, it's what the IRS and New Mexico Workforce Solutions says. I'll give you an example. I'm a lawyer. If I hire a painter to paint my office, they're going to provide the tools. They're going to probably define when they're going to come and do it, and then they're going to disappear and I'll never deal with them again. That's a contract. If I hire a lawyer to provide legal services for a client because I'm a law firm, that's different. Workforce Solutions says they are an employee, especially if I keep them around part-time or on and off, indefinitely. That's going to look like an employee. So if you're a salon or spa or, restaurant and you're hiring people to help you and they come and go seasonally, doesn't matter. They're seasonal employees, not contractors. The other thing with employees and contractors is you want to hire the right fit. And when you interview somebody and you get a warning sign, any sign, don't do the hire. So what do I mean by that? Well, if I hire somebody and they don't show up on time and they look like a mess, well, I'm not going to hire that person because the interview is probably the one time that they should be acting at their best and they can't even show up on time or dress, nicely or appropriately. So even simple stuff like that, warning signs, don't do it. If you feel like, they're hostile to you or if you're a female and you feel like they're not being respectful to you, don't make the hire. They will not get better when you hire them. They're going to be at their best on the interview. And if you hire somebody that's not a good fit, you're increasing the chances there's going to be a dispute between you and them. And then what? They're going to end up suing you for discrimination or, doing something wrong. So don't hire people that you feel aren't going to be a great fit. Partners in your partnership, meaning part owners of your business, treat them as seriously as you would a marriage. Can you trust them? Can they be loyal? Can they be honest and trustworthy? Do they have the same values as you? Are you, I call it a culture fit. Do they, do they burn the midnight oil like you do? Or are they 9-to-5ers like you? You want to hire people that are going to work the same and Do you like people who smile and say please and thank you? And if you're hiring a partner that's a narcissist and you think they're going to get better once you give them a sweeter deal, that's not going to happen. Narcissists eventually are going to turn on you. So never hire or partner with a narcissist if you can avoid it. The other thing is you want to make sure the partnership is properly documented. So if you have an LLC, that means a good operating agreement. And you think through the edge cases. What happens if something happens to them? Do you want to take the business over, or do you want to do business with their family? What happens if they start working? Can you kick them out? If so, what does that look like? How much does it cost? Do you have to buy them out, or can you just kick them out? Those kinds of things need to go in an operating agreement, and they need to go into the operating agreement now when you have a great relationship with them and when you're starting the relationship, not later when the relationship is broken down. That's a great way for a very expensive lawsuit, is no operating agreement with an LLC and then a partnership dispute, for example. With clients and customers, make sure your services, if you provide services, are properly scoped. Use SMART goals. And I'm going to give you some examples of that in a minute. If you have an intake form or a contract, a work estimate, a proposal, something written that has definitions, dates, quantities, qualities that are SMART, that can be measured and defined. You also want to, I can't tell you how many businesses out there don't have these basic clauses I've listed here: limited warranty, attorney's fees, indemnities. And also one other one would be a limitation of liability. Now, why do I say attorney's fees? It seems self-serving, doesn't it? Because I'm like, oh yeah, you got to pay for the lawyer. No, the issue is if somebody is going to play hardball with you and yank your chain, well, it's nice to have attorney's fees in your contract, because guess what? If somebody's going to yank your chain, well, they better win the case, because if they don't, they're going to pay your attorney's fees. So attorney's fees keeps people honest. They're not going to go and fight with you and sue you for no reason unless they have a legitimate belief they can win, because they sure don't want to pay your lawyer's fees. And so I would tell you, if we had 100 people, two groups of people, each at 100, and group A had a contract with no attorney's fees clause, and group B had the attorney's fees clause, 95 of group B's folks, we'd be able to resolve the dispute without going to court. Group A, without the attorney's fees clause, 50-50. 50-50 chance whether we're going to court or not. So it really pays to have an attorney's fees clause in your customer agreements, your intake forms, whatever it is, however you're interacting with your clients or customers. Finally, landlords and other vendors, you want an equal and balanced contract. Landlord, I promise you, if you have a lease, look at it. You're going to see at least 2 or 3 paragraphs, possibly a page or more, dealing with tenant breaches, and there's going to be hardly anything, if anything at all, regarding landlord breaches. And I think that's ridiculous. A landlord can breach a contract as just as much as a tenant. And when a landlord breaches the contract, it's devastating for your business. So you need recourse. If the landlord's going to breach, you need recourse. And so that would be one example of many in a lease. But there are other issues that you want to think about, equal and balanced. One is if you're hiring a vendor to provide services to you, make them have SMART goals. So it's specific and measurable and realistic, time-bound. You want that so that you can hold them accountable if they don't deliver. Because guess what? It's easy for them to hold a contract against you to pay money, because that's easy to measure. I didn't get the check. But if they have to provide services, let's say marketing services, well, how do you measure that, right? Do you measure it by how many new clients come in the door? I bet you're not going to find a single marketing company willing to agree to that. Well, then what the heck are they doing? And how do you hold them accountable? And why should you sign that 1, 2, or 3 year contract if you can't hold them accountable? So don't do that. Make them agree to SMART goals. And then you want to give yourself options. Don't forget to do that in case you breach. Sometimes, especially with COVID, right? If you're a non-essential business, all of a sudden, what do? You can't, that your key employee got COVID, or a family member in the household got COVID. Now they're supposed to stay away for the next few days. How do you handle that? So make sure you give yourself outs, make sure you have, the right clauses in place under the right conditions so that you don't yourself create a breach situation that can get your company sued. Formal business records. This is really important because I think a lot of people forget about this issue. And the issue is the following: evidence, proof. How do you prove your facts and circumstances? And you guys, I assume, are business leaders or wanting to be business leaders. And here's a news flash that you probably already know. Some people lie. There are liars out there. And how do you prove that somebody is lying? The worst possible thing that you can get yourself into is a he said, she said kind of thing, right? I mean, it's your word versus theirs. So what you want to be able to do is use what's called business records. And what most people don't understand is courts don't allow you to just bring in any kind of paper. You have to prove and show it's a business record. And what is a business record? A business record is something that you keep in the ordinary course of your business activities. So these are contracts, these are receipts, these are incident reports, if you have such things. They're timekeeping for payroll. I can't tell you how many clients I've had that don't keep track of time. And then they're really upset when an ex-employee says, hey, they didn't pay me overtime properly. How do we defend ourselves against that claim if we don't keep track of payroll and we keep those records on file as appropriate? So you want to do that. Also, new hire information, W-9s, resumes, you need to keep a hold of all of that for many reasons. And the worst thing you want to do is have somebody, claim you're discriminating, and you're able to pull up old records and say, what are you talking about? I hire people of all persuasions, so you want these records to be able to help back up or bolster your case. If you don't have these records, you're in a he said, she said, and that can create huge problems for you because guess what? You're a hurried business person, and the jury's going to want to believe the grandma, right? I mean, you don't want to put yourself in that situation. So let's talk about SMART goals briefly and why they can reduce risks of lawsuit. SMART goals help manage expectations. I'm going to give you an example here. I used to be a consultant in the city of Chicago a million years ago. I'm now in my 50s, and I'm talking about in my late 20s and early 30s. And we would burn the midnight oil. And I had another coworker. This was probably about 9 o'clock at night. I'm still in the city, still in my office. A coworker pops their head in and says, hey, I'm gonna get some food. Do you want some? I say, yes. And then they disappear. And so that sounds great, right? Well, 30 minutes goes by and I still don't have any food. 45 minutes goes by, no food. An hour goes by, no food. And now I'm pretty upset, but I don't know what to do. Do I just assume they've given up on me? Do I assume that the food's going to come any minute now? And did they know that I'm allergic to peanuts? I'm not, by the way, but I could have been. So I have all this FUD, don't I? Fear, uncertainty, doubt, just simply because they didn't manage my expectations, right? They could have said, look, I'm going around the corner. I'm going to McDonald's. I'm going to get some hamburgers for myself. Do you want one? Do you want a drink, right? They could have managed all my all my anxiety simply by giving me a little bit more information. That's kind of what a SMART goal is. So SMART goals are, they are specific, they're measurable, they're time-based. And let me explain specific. It's being clear about what we're going to do. And the more narrow, the more specific, the better. And I have an example here. If I'm a um, exterminator and somebody hires me, I don't want to say, oh, I'm going to get rid of all your bugs. What does that mean? I want to say, I'm going to eliminate your ants and cockroaches using an organic insecticide approved for use within commercial restaurants within the state of New Mexico. That's being specific on what I'm doing. I'm saying what I'm going to do, what product I'm going to use, and is it legal or not for the specific type of business that I happen to be exterminating. Measurable. What does that mean? And we want evidence of progress. So back to extermination. You can imagine how much trouble I can get myself in, right? If I just said, oh, I'm going to eliminate your bugs. Well, no, I'm not going to eliminate your bugs forever. I'm going to be able to eliminate your bugs for some period of time, right? So I'm going to say no ants or roaches will be found within your premises for at least 30 days. So that's measurable, right? Because we can, or am I going to say no more than 5 roaches or ants? I don't think anybody would hire me if I did that. But at least, that is a measurable thing. And achievable. Achievable is important, right? Because I can't make that promise of no ants or roaches if, for instance, there's an adjoining premises I don't have access to. So I need to be aware of my ability to deliver and achieve on my promises, which would be, the other pieces that are specific and measurable that I just mentioned. I'm not going to talk too much about relevant or time-based, but it's really good and important to put a time frame around things and, make the promises that are relevant to the job. Don't be making irrelevant promises. You're just going to get nowhere with that. No, and let me stop for a minute and ask other questions. I've been moving pretty quickly. I have watched the chat in the QA and I'm not seeing anything. But if you have anything, hit me up. And let me jump into what knowing the law is and how you want to make sure you don't trip over it. You want to obviously be aware of the laws that impact your business. And there are some laws that are going to affect your business, even though it's not your primary business. And I'll give you one: copyrights. If you have a website or you have an app that helps interact with clients or customers with social media, and you hire a vendor to do that, you want to make sure that you have the vendor sign a contract that gives you and assigns you the copyrights. It's called a work made for hire. You want that language in the agreement so that you own what it is they produce. Also, you can get in trouble if they copy somebody else's work, like a photo. So you want to make sure that they agree to indemnify you and hold you harmless against any infringement action that they might throw your business in. And why do you care about that, by the way? Well, and I'll give you an example. There's a guy, I don't remember his name, produced some beautiful photos of the sandias and balloons. And for whatever reason, a lot of businesses like to use those images and put them as backgrounds. Well, if you go and do that without properly licensing the image, this guy, he doesn't make money on the licensing. He makes money because he has a law firm in Manhattan somewhere that goes and finds the illegal use of these images and then demands statutory damages. What are statutory damages? Well, I explained them earlier. What are they for? Copyright infringement action for a validly filed copyright. You ready for this? $75,000 per infringing use. On your website, times 1. You put it in your brochure, times 2. You're using it in a commercial, times 3, times the number of times the commercial has been shown. So you can quickly find yourself in a devastating lawsuit if you're not careful with that. So you also need to understand the basic employment laws. And I did explain some of that to you on a previous slide. You really owe it to yourself to know the distinctions between the 1099 and W-2 differences of employees versus contractors. I also just mentioned the work made for hire doctrine in U.S. copyright law. That has a big impact on people. Finally, you need to understand this, the laws of agency. What is that? As a business owner, if you have anybody helping you, an employee, a contractor, lawyers, vendors, they are your agents. And if they go and cause problems, even if you told them don't do it, even if they do it without your permission, they are still an agent of your business, and your business is responsible for the harms and damages and liabilities they incur in furtherance to your business. And so you may be thinking, well, if they're going to go and do something without my permission, how can I possibly manage against that? And the answer is you make sure you hire the right people that are going to listen to you. And then you also, maybe you need to train them. Maybe you need to make them sign 3 times and look in you in the eye and say they're not going to do something. But you really need to take control of your business and your people and make sure they don't hurt people. So for example, you got to go and drive across town all the time to pick something up. And so you want to hire a low wage, somebody in high school to do that for you. Maybe that's not the best idea if they're not that responsible and they're going to drive really fast or recklessly. So maybe you want to hire the opposite side of the spectrum, somebody who maybe is, a little more seasoned and experienced and drives slowly and more responsibly. You need to think through those issues. And guess what? Hopefully, knock on wood, you're not going to have problems for years. But the one time you have the problem, it could be potentially devastating. Make sure you're properly licensed and permitted as appropriate. I know this seems like a no-duh, but if your license is suspended or you're not sure, or you're licensed in the city of Albuquerque, but not in Los Lunas, you can have problems in Los Lunas, even though you're properly licensed in Albuquerque. So if you have a state license, that will apply statewide, but there are many licenses more on a local basis or restrictions on the permits or licenses that you might get. And do not rely on a local permit or license for a neighboring jurisdiction. You need to go through the effort and get a new permit or new license as appropriate. Let's talk about stacking the deck in your favor. What does that mean? Well, small things can have a huge impact. And one of them is insurance, of course. Never, ever let insurance lapse. And don't think you know better. Do you have workman's comp today? A lot of people will skip on that for some reason, or they think, oh, it doesn't apply for contractors or myself. And that's not true. If you have 3 employees or more, 3 or more, that's 3, 4, 5, including owners, including contractors, you're by law required to have workman's comp insurance. So, and it's not that expensive. So you absolutely have to get that. You also want general liability. And then you need to talk to a competent broker or agent that can give you good, solid advice on what other policies you might need depending on what you do. For me, I'm a lawyer. So yes, I have a general liability policy, but I also need a professional liability policy. For many other industries or businesses, it's called an E&O policy, an errors and omissions policy. And that is for me, professional liability. If somebody wants to sue me because they think I've given them bad legal advice. But guess what? We sell stuff on the internet. So we also have cyber insurance. So that protects us in case we get hacked or there's fees or some sort of problem associated with the internet. And you have to look at your specific business and decide what other policies you may or may not need. Now, here's something you need to understand. Insurance will not defend against intentional acts. What is an intentional act? Well, you hired an axe murderer and they go and start axing up people or things. That would be an intentional act, even though that was not your intention. It was the intention of one of your agents. So you need to ask your insurance agent, well, what happens if I hire an axe murderer? Ask them that. They'll laugh and then they'll say, well, we probably need an umbrella policy, or maybe we need to add a rider to your general liability policy. And you really need to think through those issues. Key clauses in contracts will help you stack the deck in your favor. And I mentioned the attorney's fees clause. For instance, look at your contract today or your intake form or whatever you have with your customers and see if you have a dispute resolution policy. And does it award attorney's fees to the prevailing party? If it doesn't, add it. It will save you a tremendous amount of money later on if there happens to be a dispute between you and one of your customers or clients. I also listed here, I mentioned dispute resolution policy or procedure, but that includes choice of law and jurisdiction for disputes. So if your customer is in the same county as you, that isn't such a big deal. But if your customer is on the other side of the state or in a different state, it's hugely important because you want to be, you probably know New Mexico law better than you know Texas, Colorado, or Arizona law, for example. And so you want to be judged on New Mexico law, not one of the other states. And if somebody's going to sue you, make them come here. Make them sue you in this county that you're in. Don't let them sue you where they're located, because guess what? You got to go hire a lawyer over there. You may have to drive or fly over there. So you make your life a lot easier. And when you hear easier from a lawyer, think less expensive by forcing them to come here to your county and to your location if they wanted to sue you. The other thing is that people often overlook is available cash and resources. And what do I mean by that? Well, time and again, a small business ends up getting royally shafted by somebody who has more money than them because they can't generate the money necessary for the retainer, or they can't stay in a lawsuit. And they end up having to literally just give up and then do what the other side is demanding. So it helps to have a line of credit. If you don't think you need a line of credit, that's great, perfect. Go and get one. Don't use it, but you have it available to you if you need it. That's the whole point of a line of credit, is for a rainy day. And a lawsuit may be just that rainy day, and it's really helpful to have it available to you. The other one is, this seems a little self-serving, but early legal representation. And what do I mean by that? Well, every day, I get calls from existing clients, and they're asking me a 3-minute question. And guess what? I bill them for 1/10 of an hour because they've spent 5 or 6 minutes with me on the phone. They had a simple question. I gave them a simple answer, and now they have the answer, and they know, ooh, they can get in trouble, or ooh, cover their butts, document this, write it down, something. So it helps to guide them properly. And so find somebody, a lawyer or somebody that you trust, so you can ask quick questions. And if you start getting a dispute territory, you can then ask them, how do I manage this? How do I make this go away? And a good lawyer is going to be able to tell you the right directions to take to try and minimize the risk of the chance of a potential lawsuit. And then finally, this cannot be overstated: trust. I highly recommend you buy a trust book. There's several out there, and they sort of explain the concepts of trust. And trust acts, it's this funny thing. If you don't have it, it acts like a friction. People aren't willing to trust you. They want to ask a million questions. They want to talk to other people. They want a lot of, documents. If you have trust, they don't ask so many questions. They don't have so many demands. They're willing to accept the words coming out of your mouth. So you want to develop trust, and you want to look at your business and the people. And do they have your trust? Do you do what you say? And if you have built up that trust, it's going to reduce lawsuits. It's going to reduce expenses because people trust you. They are going to want to maintain your favor. And so it's going to help reduce lawsuits and costs associated with that. And it's really something that you should try and work towards and attain. It's not just the words out of your mouth. It's the brand promise. It's your people. Is you and your business doing what you say you're going to do? Are you following up? Are you admitting when you make mistakes? And are you fixing mistakes and problems when they occur? That goes a long way to solving problems and, again, stacking the deck in your favor. So what do you do if you are sued? The first piece of advice is stay calm. Don't get angry. Don't threaten. Don't, make 50 calls in a panic. Take a deep breath and stay calm. That's what's really important. So don't panic, but don't delay either. When somebody files a lawsuit, clocks start ticking. Depending on the court, you will have either 20 or 30 days to respond to an action. And so you want to give the lawyer time to respond to a complaint. But don't be dumb either. Don't agree to a settlement and without having a settlement agreement. Avoid talking to the other side, especially if they're a lawyer, because they are not serving your best interest. They are serving the other side's best interest, and they have no legal need or ethical requirement to guide you or be honest with you. And so don't expect that. And if you have a company, an LLC or a corporation, you can't represent that corporation or LLC in court. And so you're going to need to hire a lawyer. So don't try to hire somebody. And if you have a lawyer on the other side, they are trained. I'm a lawyer. I had to get an undergraduate degree. I have it in electrical engineering for New Mexico State. That took me 5 years to get. Then I needed to go to law school, 3 years to get a Juris Doctor of Law. And then I've been practicing law for 27 or 28 years. So you think you're going to be able to out-navigate somebody like me in the court system? Just think it the other way around. You are an expert at, baking or, travel and tourism. Do you think I would be able to outbid you or manage you in a business in what you do? No way. And you're not going to be able to do that with me or other lawyers. So please don't try. You're going to get yourself in trouble. The other thing you need to be aware of is you've got to call your insurance company, and you need to do this right away. Within 24 to 36 hours is the time frame. You call your agent. I've been sued. What do I do? And depending on the insurance, depending on the lawsuit, they're probably going to take it over and run with it. But depending on the circumstances, they may decline coverage. They may decline to cover to defend you. But if they decline coverage, still ask them, does that mean you're not defending me? And sometimes insurance companies can be difficult. And if so, you might want to talk to a lawyer because they might have a duty to cover you, or at least a duty to defend you. And so what we'll find is sometimes the insurance companies will say, look, we think there's a problem. We think we're probably not going to cover this, but we're going to at least defend you. And defending you is really important because that is expensive and you don't want that to happen. And so finally, you got to pull together the funds. If the insurance company isn't going to defend you, then you're going to have to pull the funds together and hire a lawyer. And that's when you want to contact an attorney. They're going to want a retainer. And a retainer, what is that? That is it's almost like a prepayment, but it's your money. So it goes into a trust account. And most lawyers are going to want a retainer anywhere from 20,000 to 5,000 in that range, depending on the circumstances and issues. And that money is going to go in a trust account and the lawyer is going to bill against it. So if you were to hire me in a lawsuit, I'm going to tell you I need a $10,000 retainer. And so if you paid me that $10,000 retainer, it goes into a trust account. And then let's say you fire me the next day and I do no work. Well, guess what? I owe you that $20,000 back. Let's say you hire me and I do a week's worth of work and it totals up to $1,000. And then you decide you want to hire somebody else and you fire me. Well, you got to pay me that $1,000. I'll take it out of the $10,000 retainer, but I need to pay you back that $9,000 because that's your money, not mine. That's how a retainer works. So how do you hire the right lawyer if you're sued? Well, there's a certain strategy around this that I think is important. The first one is, find out if the insurance company is going to defend. And you really got to bug the insurance company, by the way, because I've found it could take the insurance company days or sometimes weeks to get back to you. In the meantime, you got to file an answer within 20 to 30 days of when you've been served. So you want to find out, quickly whether they're going to help you. And then you got to also find a lawyer yourself if they're not willing to do it. So give yourself plenty of time to do that. And what kind of lawyer do you want to hire? Well, there's some things you need to understand about lawyers and litigation, and I'm going to explain them to you, and they're extremely important. The first issue is aggressiveness. And a lot of people are like, oh, I want to hire the most aggressive lawyer I can find. I want a shark. I just want to tear the other side to pieces. Guess what? We lawyers love doing that, but it's extremely expensive because of the following. The other side is aggressive too. So what does aggressive mean? Well, aggressive means I'm going to raise a fit with everything you say. I'm going to challenge everything you say. I'm going to hire better experts than you. Well, what do you think a better expert is? A more expensive expert. So aggressiveness is very expensive. It doesn't necessarily mean faster either. So if you are a business or an individual with an infinite source of funds, aggressive is certainly a great choice. However, at least for me and my businesses, that my clients, they're small and medium-sized businesses, they can't afford aggressive. They think they want it, but they don't want the bill afterwards. So you have to decide, what is the right lawyer and the level of aggressiveness that you want. The other thing is, to be aggressive means you want the other side on the defensive. Well, if the other side is aggressive themselves, it takes a lot of work to get them on the defensive. But being on the defensive isn't as bad as you think it is. We all, time and time again, there are certain firms in town that are just super hyper aggressive. And when they're involved in a lawsuit, we have to tell our clients, oh, great, it's the other firm, they're super aggressive. And that means we're going to have to respond to a lot of stuff. That's all it means. We can respond to it. We're not afraid to respond to things, but we are going to have to respond to a lot of stuff. We charge for our time, and that will tend to be more expensive for our client, unfortunately. It's going to be a lot more expensive for the other side, but it's still going to be expensive on our side. And that is a strategy. We can be defensive because guess what? We're still going to have good experts. We're still going to say you guys are wrong on our responses. And then we're going to let the judge decide. And guess what? Judge is probably going to like us better than they're going to like them because the judge knows they've been too aggressive and that we're trying to be reasonable. Judges love reasonable people. But there's another aspect of hiring a lawyer, and that's communication. So a lot of clients want constant communication. And you know what? That is totally fine. That is acceptable. If you are somebody that needs daily reports and communication, that's okay. But guess what? I'm having to talk to you and I'm charging you for my time. And I have other clients too. So if you want to talk to me every day or be dedicated, we can certainly do that, but be ready to spend a lot more money. And so the opposite of that is less communication. And every once in a while, we'll get clients who want very aggressive, very communicative, but they don't want to spend a lot of money. And that's just not, that just doesn't work out right. That is a recipe for failure between me as the lawyer and they as the client. And so I, as a lawyer, if I can recognize that, then I'm going to tell them I'm probably not the right lawyer for them. And I like to think my firm can do both. We can either be aggressive and or very communicative or the reverse. But we need to understand what our client wants. And so we will try to help our clients understand this and work with them, but sometimes they themselves don't know, or they themselves haven't really encountered this before. So it's really something for you to understand, and that is a perfectly acceptable thing to talk about the lawyer with. Are they super aggressive? Are they super communicative? Are they the opposite? Are they willing to be flexible? But most importantly, are they willing to meet your specific expectations? That's what's important when hiring a lawyer. Can the lawyer meet your expectations? Cost is clearly a component of this, but don't just hire on the retainer. What is their hourly rate? Do they have a minimum amount? I hired a divorce lawyer because I'm not a divorce lawyer and I went through a divorce. I went through more than one divorce, but that's a topic for another day. But that dang lawyer, every time he called me, he charged me 0.2 of an hour, even though it was like a 3-minute call. And that adds up over time and it pisses me off. And I eventually fired that lawyer. So find out what their minimums are, if anything. And are they available? Are they willing to give you the time of day? Are they respectful to you? Do they understand your business and the subject matter of the lawsuit? Have they done it before? And the communication style and the aggressiveness. It's fair to ask the lawyer these things. And if they're going to get, they're going to say those are stupid questions or they're not going to be respectful to you, don't hire them. You have to have a good relationship with somebody. And by doing that, you're going to hire somebody you trust, and then it's going to help keep your legal fees where you need them to be for your business. And that's how you can have a successful lawsuit. Well, there's no such thing as a successful lawsuit.
Larry, we do have a question that was emailed to us, and the question is it illegal to ask clients for proof of vaccination if they want in-person sessions? We're not denying services, just offering virtual and phone options. How do we protect ourselves physically and legally?
That's a really good question. And the law is not fully settled on this, unfortunately. So the question is, well, there's two pieces to this. One is, can you ask the question? And the second thing is, can you demand proof? And what I'm going to tell you right now is that's very dangerous territory. You can clearly spell out your requirements for your business and present them. For example, on your front door, you can come in if you've had a vaccination. Otherwise, if you don't have the vaccination, you're not permitted in. You can certainly put that on your door and let them make the decision. But at the moment, until we get better guidance, I'm going to say avoid questions like that until the law is better settled. And the reason I'm saying that is to avoid lawsuits. I don't want somebody coming back saying you violated HIPAA or some sort of discrimination because of that.